Good morning, everybody. Thank you so much for being here and joining us. And just wanted to acknowledge the Veterans Day holiday and take a moment to thank any veterans here for their service. And certainly we should keep veterans in our mind every day, but especially today on this special holiday. But we're here all together anyways, and we have the benefit of hearing from Dr. Chinmoy Gulrajani today, who's a board-certified psychiatrist with subspecialty certification in forensic psychiatry. He's a medical specialist in forensic psychiatry with the Minnesota Department of Human Services and an adjunct assistant professor of psychiatry in the Department of Psychiatry here at the University of Minnesota. I just wanted to say that we have this wonderful collaborative relationship between the state and our department to be able to benefit with Dr. Gulrajani in-house teaching our learners, and that's been really an innovative collaboration and benefited us tremendously because this is such an underserved area. Dr. Gulrajani serves as the program director for our new fellowship training in forensic psychiatry, which was approved this year by the ACGME, which is huge. We've tried this before and it hasn't worked, and so Dr. Gulrajani actually made it happen. It's very exciting for us. And he's also involved in resident and medical student education. Prior to joining the University of Minnesota, he was medical director for inpatient behavioral health at Kings County Hospital Center in Brooklyn, New York, and a consultant forensic psychiatrist with the trial and Supreme Courts in New York City. Dr. Gulrajani attended medical school at the University of Delhi in New Delhi, India. He completed residency training at the University of Delhi, University of Missouri, Columbia, and Yale University. Subsequently, he graduated from fellowship training in forensic psychiatry at Yale University, and he was the recipient of the Lilly Young Investigator in Bipolar Disorder Fellowship in 2003 and was awarded fellowship of the American Psychiatric Association in 2014. Thank you so much, Dr. Gulrajani.
Hi, good morning, and thank you all for being here to discuss this exciting topic, one which is really not discussed very often in contemporary psychiatric circles these days, and definitely not in Minnesota because Minnesota does not have the death penalty. Nevertheless, in the last 50 years, there have been several Supreme Court decisions and opinions, which I'm sure many of you have read about, that have really shaped and expanded the role of psychiatric involvement in death penalty cases. But to get a good feel of how it all began, we really need to go back to the 17th century. My talk today is titled Death Penalty and Psychiatry, a Historic Overview. In the next 40 minutes, I'm going to try and accomplish the daunting task of summarizing 5 centuries of American history, or 5 centuries of capital punishment in America. So without further ado, I'd like to get started. Before I do, I have one more slide to show. I have no disclosures or disclaimers. I'm in the process of completing a paper on this subject, so please bear with me while I read from the paper today. And the screen will serve you well. So capital punishment was introduced in America by European settlers in the early 17th century. In colonial times, there were no prisons, and death was the standard punishment for a myriad of crimes against person, property, and morality. Most colonies at the time adopted some version of English penal code, and the list of crimes for which a person could be sentenced to death was virtually endless. So you could be put to death for stealing spoons or murdering a pet. The preferred method for execution during this era was obviously hanging, as the picture says, though sometimes more elaborate and more painful methods were used for severe crimes. So more elaborate methods like gibbeting, the body was actually encased in iron rods and hung, and for all to see, and the whole village could see it slowly getting decomposed or decayed. Sometimes there was crucifixion or quartering or disembowelment or burning. In those days, trials were conducted speedily, sometimes as many as 4 to 5 death penalty cases in a day. And execution was a public affair with an audience from all walks of society. The hanging itself was an elaborate ceremonious affair, It went on for several hours, and it was punctuated with sermons, speeches, and public declarations. Crowds amassed in large numbers, sometimes in tens of thousands. They wanted to express their disapproval of the crime and the criminal. In this form, capital punishment was seen to serve several legitimate purposes. The speed and visibility of the execution sent out a chilling message of deterrence. Execution as a means of retribution had moral sanction. An impending death facilitated a criminal's repentance in his final days, thereby also affording expiation to society at large. In the beginning of the 18th century, insanity gained prominence as a formal defense in English courts. For some of you who are history buffs in psychiatry, it was in 1723, Lord Justice Tracy in England laid down the wild beast test of insanity. One of the earliest known cases where psychiatric expert testimony was utilized was the 1760 murder trial of Lawrence Earl Ferrers, who was accused of having shot his servant to death. This was before the House of Lords in England. The physician in that case actually testified that Lawrence Earl Ferrers was malingering his psychiatric illness, and unfortunately for the Earl, he was convicted and hanged shortly thereafter. A few decades later, in the famous trial of James Hadfield, who was acquitted of murder trial of an attempted murder of the King of England on the grounds of insanity, and this was assisted by the testimony of physician Alexander Crichton, thus marking one of the earliest involvement of a psychiatrist in a capital case. Now, what was going on in the United States during this time? Slowly, there was opposition gaining momentum in the United States at this time because Americans began to view death as too harsh a crime, too harsh a punishment for crimes of property. But it was really an Italian philosopher by the name of Cesare Beccaria who had the most profound influence across the globe. In 1767, Cesare Beccaria wrote a book. It was called Essays on Crimes and Punishment. And in this book, he challenged the state's authority to punish crime with death. Does the state have a right to take away a man's life for any crime, no matter how severe? And he also emphasized that prolonged imprisonment is actually a better deterrent than taking away the life of the person. Now, within the United States, the opposition movement was spearheaded by two known personalities. One of them was Sir Thomas Jefferson. In 1778, Thomas Jefferson drafted a bill in Virginia calling for a revision of death penalty laws. His bill was defeated by one vote in the Senate. Simultaneously, in Pennsylvania, Sir Benjamin Rush, who is the founding father and the father of modern American psychiatry, called for abolition of the death penalty. Soon thereafter, in 1794, in response to efforts of Attorney General William Bradford, Pennsylvania became the first state to repeal the death penalty for all crimes except first-degree murder. Soon thereafter, several northern states followed suit, and they started modifying their sentencing schemes to abolish the death penalty as a penalty for lesser crimes. Although a few states went the opposite direction, Massachusetts and New York, for example, brought it back for crimes like rape and arson. The abolition movement gained further impetus in the first half of the 19th century. Critics began to question the extent of repentance that a criminal could achieve in the few days between conviction and execution. In addition, the first penitentiaries were constructed in several states. This is the Eastern State Penitentiary in Philadelphia, Pennsylvania, that became operational in 1829. These penitentiaries offered to serve the goal of reform as an alternative to short-lived repentance before execution. During this period, physicians in America were focused on investigating the organic determinants of criminal behavior. In 1812, Sir Benjamin Rush wrote the first treatise on insanity, titled Medical Inquiries and Observations into Diseases of the Mind. In 1824, a scientist named Charles Caldwell posited the theory of phrenology. For those of you who know phrenology, it is now considered junk science or pseudoscience. But this was one of the first biological theories of deviant behavior. A few decades afterwards, the hereditary approaches and theories were put forward. Scientists started saying that crime is transported through genes and the genes are heritable. However, the medically oriented approaches never gained significance in society. In 1838, Sir Isaac Ray, who was at that time 31 years old, he's certainly not 31 in this photograph. He was a 31-year-old general practitioner from Eastport, Maine, and he published a treatise on the medical jurisprudence of insanity. This was the first comprehensive American text in forensic psychiatry. In this book, he laid out several different types of insanity and the characteristics of each type. 5 years later, this book was extensively quoted in the famous trial of Daniel McNaughton. This is Sir Isaac Ray's book. Let me go back and show you what the cover was like. And this is Daniel McNaughton, for whose name gives us the legal standard for insanity in majority of the states in the United States. Daniel McNaughton was a Scottish woodturner, and he set out to murder the British Prime Minister. Instead, he mistakenly murdered another lord, Sir Edward Drummond. And in his trial, 9 psychiatrists testified that he was insane. This led to a furor. The Queen was very angry. How can you pardon someone who actually tried to kill the Prime Minister? And so she asked the House of Lords several questions. And the answers to 2 of those questions became what are today known as the McNaughton Rules. These rules were very quickly adapted by English courts and most American courts as the legal test of insanity at the time. In the years that followed, psychiatrists vigorously debated on what should be the right test for insanity. Many psychiatrists still feel that the McNaughton rules are very restrictive. So in the aftermath, several states switched to other legal tests. But even at this point, psychiatric involvement in death penalty cases was restricted to the trial phase. Psychiatrists were only testifying about the state of mind of an individual when he was actually committing the crime. As opposition to capital punishment spread in America, state after state removed the death penalty from lesser felonies. The first National Death Penalty Abolition Society was formed in New York in 1845. The very next year, 1846, Michigan became the first state to abolish the death penalty for all crimes. It was soon followed by Rhode Island in 1852 and Wisconsin in 1853, which were the only other 2 states to enact abolition before the Civil War. This movement, however, lagged in the southern states, where the social and economic importance of slavery prevented the culture of reform from emerging. The list of crimes punishable by death was only shortened for whites, while blacks continued to be executed for lesser crimes and in far greater proportions than their white counterparts. In the summer of 1887, a little-known engineer named Harold Brown, who was backed by Sir Thomas Edison, started conducting public experiments in New York to determine why electric shock was fatal to animals. Soon thereafter, the New York legislature appointed a commission to investigate and report on the most human and practical method known to carry out the death sentence. This commission came back with its report in 1888, and they considered 43 alternatives. They deliberated, and they decided that death by electricity was their choice because it was painless, it would not mutilate the body, and did not require the expensive equipment required for hanging. The same year, New York dismantled its gallows and constructed Old Sparky, the first electric chair. Between 88 and 1913, 15 states adopted the electric chair, and by 1950, even more states and the District of Columbia had followed suit. The movement to abolish the death penalty waned in the second half of the 19th century. Activists devoted most of their energies into more prominent issues of the day, like slavery. This movement came to a complete halt during the Civil War, only to be rekindled at the turn of the century. In 1910, the Supreme Court heard the case of Paul Weems. Paul Weems was an American officer charged with defrauding the government of Philippines. He had committed forgery. The Philippines was an American colony, and the highest court in Philippines gave Mr. Weems a punishment of 15 years of rigorous labor and a fine of 4,000 pesos. Mr. Weems appealed to the Supreme Court of the United States, and he claimed that this punishment is cruel and unusual as laid out under the Eighth Amendment. The court's opinion in this case set an important precedent and would reshape the debate on capital punishment in the United States for all times to come. Specifically, the court held that cruel and unusual punishment is defined by the changing norms and standards of society, and therefore is not based on historical interpretations of our forefathers. Between 1907 and 1917, 9 states abolished the death penalty, but the change was permanent in only one. Would anybody like to guess which one that was? It was Minnesota in 1911. While in the rest of the 8 states, public opinion was driven by high-profile murder cases and the death penalty was rapidly reinstated. The number of executions rose till 1935 before embarking on a course of steady decline. In the quest for more humane ways to carry out the death sentence, in 1921, the Nevada legislature passed laws allowing for execution by lethal gas in a gas chamber. And this is Nevada's first gas chamber. And Mr. G. John, who was a gang war murderer, became the first person to be executed with the use of cyanide gas. Despite its perceived advantages, the gas chamber never really took off as a popular means of execution. There was something very creepy about watching an individual sit while watching him through those windows while a poisonous gas filled up the room, waiting for him to die, a process which took several hours. And the gas chamber never really became a popular method of executing individuals. Now, this was also a period of intense abolition. Please, Dr. Realmuto.
This is astounding. Looking for the guilt-free method of killing people. It's just astounding.
And we'll come to all those thorny questions in a bit. So we are in the early part of the 20th century, and this was a period of intense abolitionist activity in the United States. Several celebrities joined the cause of abolition, and nothing gets a cause going like celebrities, right? So the first of these, and one of the prominent ones, was William Randolph Hearst. I don't know if anybody's seen the HBO series Deadwood. There was a minor featured in that series, George Hearst. George Hearst was a minor and later went on to become United States Senator, I believe from one of the Dakotas. His son was William Randolph Hearst, who became a newspaper magnate and spearheaded the cause of abolition in the United States. The other prominent celebrity who joined the cause was Sir Henry Ford. Now, for the first time, questions were raised about the unequal application of this sentence. For the wrongful execution of arguably innocent defendants planted the seeds of doubt about the fairness of this punishment in the minds of jurors. So after an initial surge, the number of executions began declining steadily in the first half of the 20th century. It was 199 in 1935. This is a 1936 photograph of the last public execution. And it dropped to less than 50 in 1961. Historians have attributed this decline to several factors. The first was an increased belief in determinism. People started to understand that crime was not a product of only free will. There were social determinants to crime, where a person was born, what their level of education was, what their early childhood influences were. Simultaneously, the role of religion declined in public life, and biblical arguments for capital punishment started losing intellectual respectability. A new breed of abolitionists, in the form of social scientists, took to the street. They were armed with statistics as their weapon of choice, and the first studies of states that had capital punishment versus those that did not have capital punishment began to show that abolishing the death penalty did not necessarily lead to an increase in crime. Therefore, the deterrent value of the capital punishment was also questioned. Now, most of this action was missing from the southern states, where capital punishment, like pest control, was deemed necessary to subjugate what was considered an animalistic black population. The South also had its own brand of unofficial justice in the form of lynching. This usually involved a black victim and a white executioner. And at its peak, lynching was far more common than official capital punishment throughout the South. And yet, the decline in capital punishment continued throughout the first half of the 20th century. Why? This was attributed to changes in the appeals process. The Legal Defense Fund and the American Civil Liberties Union took active interest, and they started representing more and more individuals convicted of death penalty crimes. And many of these individuals won, and even if they did not win, while their cases were under appeals, they lived. The number of appeals from capital cases grew exponentially, flooding the legal system, and the net result was a prolonged delay between sentencing and execution. In 1958, the Supreme Court heard the second landmark case that would alter the course of capital punishment in the United States. This case was Trop v. Dulles. Mr. Trop was a soldier who was accused of deserting the army during wartime. The penalty for this crime was expulsion from the citizenship of the United States. The Supreme Court concluded that involuntary statelessness was an excessive and therefore an unconstitutional punishment for Mr. Trop. Writing for the majority, Chief Justice Warren emphasized the flexibility inherent in the words cruel and unusual. He wrote, and I quote, "The amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society." By the 60s, most European countries, Canada, Mexico, and even Australia had abolished capital punishment. Abolitionist sentiment was higher than ever in the United States, and it's reached its peak in 1966, when for the first time, and also the last time, those who opposed capital punishment outnumbered those who did not, 47 to 42. Finally, in 1968, despite having 517 inmates on death row, the United States of America executed not one. The Supreme Court's decisions in the two landmark cases, Weems and Trops, had laid out the groundwork for a novel argument against capital punishment. But this issue did not come into the court until 1972. In this year, the Supreme Court took on a set of 4 cases which have collectively been known as Furman v. Georgia, which are named after this gentleman, William Henry Furman. In Furman, the court struck down the death penalty in the United States as unconstitutional and in violation of the Eighth Amendment's cruel and unusual punishment clause. All the judges took strong exception to the apparent arbitrariness with which death sentences were imposed under existing laws. And this often indicated a racial bias against black defendants. Essentially, the judges were saying, there is no scheme here. There is no protocol. This is all random. Who gets and who doesn't get the death penalty is just a matter of chance. And Justice Stewart wrote what has become one of the most famous quotes in American jurisprudence. He wrote, and I quote, "These death sentences are cruel and unusual in the same way that being struck by lightning is cruel and unusual." Justices Brennan and Marshall went a step further in concluding that the death penalty itself was cruel and unusual punishment and incompatible with the evolving standards of decency of a contemporary society. On the evening of June 29, 1972, more than 600 inmates on death penalty celebrated across the country. In one fell swoop, the Supreme Court had vacated their death sentence. But the celebration was short-lived. In the 4 years after Furman v. Georgia, 35 states and the federal government reenacted their death penalty statutes. Under the new statutes, death penalty trials were divided into two phases, the guilt phase and the sentencing phase. In the guilt phase, the jury only had to make a determination whether the individual was guilty or not guilty, had they committed the crime or not. In the sentencing phase, the jury could consider a whole bunch of information and decide whether this convicted defendant should be put to death or not. So what was the kind of information that the jury could consider? They could consider aggravating factors. They could consider how dangerous this person had been in the past, and was there a risk for future dangerousness. They could consider what their childhood was like. Were they a sociopath or not? Right? Under the mitigating circumstances, similarly, they could consider several factors that could help them persuade their minds and let the person live. In the 4 years that followed Furman, approximately 300 more individuals were sentenced to death in the United States, but nobody was executed because the constitutional challenge to these new statutes had not been laid. This came back again in court in 1976 in the case of Gregg v. Georgia. This time, however, 7 out of the 9 judges upheld the constitutionality of the new sentencing statutes, effectively ending the de facto moratorium imposed in Furman v. Georgia. On the same day as it decided Gregg v. Georgia in 1976, the Supreme Court also decided the case of Jurek v. Texas. Mr. Jerry Lane Jurek was sentenced to death. When his case came to the sentencing trial, the jury was asked to make a determination as to whether he's going to be dangerous in the future or not. The jury looked at all the available information and convicted him, and he was sentenced to death. Mr. Jurek challenged this Texas statute. He said, because this task of predicting human behavior is an impossible task, this statute is unconstitutional. But the Supreme Court shot down his appeal. The Supreme Court said, prediction of risk of future violence is a task that is routinely performed by various officials in the legal justice system. For example, the probation officers, the judges, and psychiatrists who testify in the courtroom, and psychiatrists who work in the ER, and psychiatrists who work in the inpatient units. And therefore, the court said the jury is allowed to look at whatever information they want to and make a determination whether this person is going to be dangerous in future or not, and announce the death penalty. Now, the empirical research at that time, I apologize. 2 years after this case was the case of Lockett v. Ohio, where the Supreme Court also lifted all restrictions on the amount of mitigating information that could be presented in front of the jury. And therefore, the sentencing phase essentially was prolonged and expanded to include whoever wanted to come in and testify about the individual's character, his history, his sociopathy, his risk for future violence. Together, these two opinions, Lockett and Jurek, opened the doors for psychiatric testimony in the post-conviction phase of a death penalty trial. Working for the defense, psychiatrists who had thus far only been giving opinions in the trial phase could now also give opinion in the sentencing phase about mitigating factors. On the prosecution side, the psychiatrist's role was much more controversial. Why? Because it required an opinion about an individual's risk of future dangerousness that could potentially lead to a successful verdict of death. Existing empirical research demonstrated that psychiatrists' prediction of future dangerousness was fraught with errors. In fact, the research at that time indicated that psychiatrists were right only in 1 out of 3 cases. Many questioned this ability, and even the American Psychiatric Association acknowledged the mental health professionals did not possess this expertise to predict future dangerousness. And thus born was the cottage industry of assessing risk of future dangerousness in the field of mental health. 6 months later, on January 17, 1977, Gary Gilmore, an arguably mentally ill man, became the first man to be executed in the United States in over 10 years. The same year, in 1977, the Oklahoma legislature adopted a new method of execution, the lethal injection. Several states followed suit, and the lethal injection was used for the first time in 1982 in Texas. By the end of the century, lethal injection had become the standard means of execution in all states that retained capital punishment. The introduction of lethal injection in Oklahoma and Texas led to vigorous debates in the medical profession. And what was the role that physicians had to or needed to or should play in the process of execution? In 1980, the American Medical Association deemed it unethical for physicians to participate in the execution process. Within psychiatry, the ethics of psychiatrists' role and participation in death penalty cases was being vigorously debated. Towards the end of the 20th century, this debate expanded to include another vexing question. Is it ever ethical for a psychiatrist to forcibly medicate an incompetent defendant on death row to restore him to competence to be executed? Organized psychiatry, by and large, rejected this notion and practice and deemed it unethical, barring very, very few exceptions. In Furman, in Lockett, in Ohio, and several other cases, the Supreme Court had opened a door that allowed for constitutional challenges to specific aspects of the sentencing process that would continue to dominate the Supreme Court's rulings for the rest of the century. In the decades that followed, the Supreme Court imposed several limits to the imposition of death penalty on the basis of evolving standards of decency embedded in the cruel and unusual punishment clause of the Eighth Amendment to the Constitution. So, in 1977, the court found that the death penalty was unconstitutional for the crime of rape. In 1982, the court decided in Edmonds v. Florida that the death penalty was cruel and unusual punishment for a minor participant in a felony crime. The next year, the Supreme Court's opinion in Barefoot v. Estelle legitimized the role of psychiatrists in death penalty cases, though it proved to be even more controversial than the Supreme Court's ruling in Jurek. This is Mr. Thomas Barefoot. He was convicted of murdering a police officer in Texas. He was convicted, he was found guilty, and when his case came in front of the jury in the sentencing phase, 2 psychiatrists testified that he was a sociopath, that there was a 100% risk that he was going to reoffend if he was allowed to live in prison. They said on a scale of 1 to 10, his score was 11. Now, the interesting thing about their testimony was that neither of those psychiatrists had ever met Mr. Barefoot. They had not even examined him. They had not asked to examine him. They had not seen his records. They had only answered hypothetical questions posed to them by the prosecution. The jury listened to the testimony of these psychiatrists, and this is one of the psychiatrists who has been nicknamed Dr. Death. I don't know how many people in the audience recognize this man. His name is Dr. James Grigson. In a period less than 15 years, he testified in over 100 capital cases, and every time he testified, Your Honor, I have no doubt that this guy is going to commit murder again. And almost every single one of his cases was executed. In the early 90s, the American Psychiatric Association expelled him on the basis of unethical practice. The sad part is he continued to testify in Texas even after that. Well, the jury convicted Mr. Barefoot for the crime of murder and sentenced him to death. Mr. Barefoot appealed, and he said, how can this statute be constitutional where the psychiatrists have not even met with me? The Supreme Court said there is no problem with this. The psychiatrists are allowed to answer questions on hypothetical scenarios, and Mr. Barefoot was eventually executed. 2 other cases in the early and mid-80s expanded the role of psychiatrists in death penalty cases. The first of these was Ake v. Oklahoma. This is Mr. Glenn Burton Ake, who was also convicted of capital crime. In this case, Mr. Burton had spent all his money and he could not afford psychiatric testimony. And the Supreme Court said that for indigent defendants, the state had to provide for a psychiatric examination. The state had to pay for a psychiatric examination if such an examination was required in preparation of defense. The other case was Ford v. Wainwright that came to the court in 1986. And in this case, the Supreme Court held that it is cruel and unusual punishment to execute the mentally ill. So anybody who is not competent, does not understand the reasons for their punishment, cannot be executed. However, in Ford v. Wainwright, the court did not clearly delineate what the correct standard, what the correct legal standard for execution is. It wasn't for another 22 years in 2007 in the case of Panetti v. Quaterman that the Supreme Court expanded on this legal standard to include rational understanding on part of the defendant. A defendant who is to be executed should not only know why he is being executed, he should also appreciate why he is being executed. This case was Panetti v. Quaterman, and the case of Scott Panetti has recently been in the news. This was a gentleman who walked into court wearing a cowboy outfit. And he was going pro se. That means he was arguing his court case himself. And the jury convicted him. Well, he's still alive. He's still not retained competence. In 1987, Hugo Bedau and Michael Radelet published a landmark study in the Stanford Law Review. They documented 350 cases of individuals who had been convicted of capital crimes in the United States between 1900 and 1985. The interesting thing about these 350 individuals was they were all innocent. In the decade following the publication of this study, scores of additional death row inmates were discovered to have been falsely convicted, largely through the emergence of DNA evidence technology. In 1988, that was 1 year later, the Supreme Court decided that the execution of individuals under the age of 15 was cruel and unusual punishment. The very next year, in Stanford v. Kentucky, the court extended this ruling to protect those ages 16 and 17, thereby vacating the death sentence of Kevin Stanford. So what constitutes psychiatric participation in a death penalty case? And who decides? And what are the ethics behind it? It wasn't until 1992 that the AMA actually even considered what constitutes participation for psychiatrists. They came up with a policy which basically said, if you're a psychiatrist and if you as much as talk to an individual who is on death row, it is unethical practice. If you give an opinion in court regarding their dangerousness, regarding their state of mind, regarding their competence to stand trial, it is unethical practice. The APA heard of this, and in 1993, the APA sent emissaries and said, you know, giving an opinion in court cannot be counted as working for prosecution or defense. And it cannot be, and the psychiatrist there cannot be held responsible if the individual is actually executed subsequently, because the psychiatrist is not making that decision. The core difference, and I know for the students in the audience, I'm sure you have repeatedly been taught, psychiatrists determine capacity, courts determine competency. So, what constitutes physician participation in death penalty trials? Any action that would directly cause the death of the condemned. So if you're actually injecting lethal chemicals into the defendant's veins. Any action that would assist, supervise, or contribute to the ability of another individual to directly cause death of the condemned. So you're not actually directly injecting the individual, but you're standing there and supervising other individuals doing it. Or any action that could automatically cause an execution to be carried out on a condemned prisoner. Well, and the third one doesn't really apply to psychiatrists because psychiatrists don't make those decisions. What does not count as participation? And this is relevant for psychiatrists testifying about the history and diagnosis and mental state as they relate to competence to stand trial, testifying about the relevant medical evidence during trial, testifying about aggravating or mitigating circumstances, and testifying about competence to be executed. The AMA also deemed it unethical for physicians to treat incompetent condemned prisoners unless their sentences had first been commuted to life. Though some prisoners were allowed to be treated if they had intense suffering because of medical or psychological illness. Just like the latter half of the 20th century, in the 21st century too, the Supreme Court has continued to impose restrictions on the application of death penalty throughout the country. So, in 2002, in Atkins v. Virginia, the court banned execution of mentally retarded individuals. And in 2014, in the case Hall v. Florida, they also expanded on the standard for evaluation of what constitutes intellectual disability. They said this clear line, the IQ number of 70 is not sufficient to determine if an individual is intellectually disabled or not. In 2005, execution of individuals under the age of 18 was found unconstitutional in the case of Christopher Simmons. And in 2008, the court also disallowed states to impose the death penalty against an individual for committing childhood sexual abuse and any other crime that did not result in the death of the victim. Now, as I had mentioned before, by this time, the most common method of execution in the United States was the lethal injection that involved 3 drugs. And the lethal part of that injection was sodium pentothal, which is a short-acting barbiturates. Between 2009 and 2011, anti-death penalty activists across the country persuaded pharmaceutical companies to stop manufacturing pentothal. This led to an acute shortage of pentothal throughout the country. So in 2013, many states turned to midazolam, a very short-acting benzodiazepine, as the single agent used for execution. And the doses required were very, very high. The inmates who were on death row had to be repeatedly injected, and this led to several botched executions throughout the country. The most notable one was this of Mr. Clayton Lockett in Ohio, who, as one of the reporters who observed the execution reported, that he was gasping for air for 40 minutes despite repeated execution. So is it constitutional to use midazolam as the single agent for executing an individual? This case was heard this year in 2015 in Glossop v. Gross, in which the Supreme Court said it is constitutional to use midazolam as the only agent for execution. In the meantime, Utah reinstated death by firing squad, and Oklahoma introduced death penalty by nitrogen gas as an alternative to lethal injection if the necessary drugs could not be found. Within the last week, 2 other new pieces of news have come out. Yesterday, California legislation said it was okay to consider from a group of 4 barbiturates to use as an agent for execution. Last week, Oklahoma postponed all its executions by 2 years because they're just not able to find short-acting barbiturates. Also within this year, Dzhokhar Tsarnaev, a 22-year-old student from Boston University, was found guilty of murder in the Boston Marathon bombings, where 3 people died and over 250 were injured, and he was pronounced, and the jury handed him the death penalty. And Nebraska became the 7th state in the last decade to abolish the death penalty, to bring the total up to 19. In the states that have continued to retain the death penalty, appeals from death penalty cases has flooded the legal system, resulting in prolonged delays between sentencing and execution. The mean wait on death row today is about 15 to 16 years. The net result has been a decline in the number of executions every year since the beginning of the 21st century, indicating a gradual but steady trend towards abolition. Today, the United States is the only Western country with capital punishment. Though it continues to be in the company of some of the most populous nations in the world, like Indonesia, China, and India, that have retained capital punishment. Even though a majority of Americans support death as a punishment for the crime of murder, this issue is very, very controversial. Critics of capital punishment claim that it should be abolished. Why? because it does not deter crime. It can never be administered without racial bias, and it costs up to 3 times as much as life in prison. While proponents argue that capital punishment is morally fair, it provides retribution, and it's not cruel if applied by humane techniques. Whether you phrase this in philosophical, political, ethical, economical, or medical terms, for the past 2 centuries, the death penalty has remained the subject of bitter debate. This debate is not new to our profession, not to medicine, not to psychiatry. History bears witness that psychiatrists first got involved in capital cases when lawyers wanted to save or protect their defendants by getting them declared as not guilty by reason of insanity. Over the years, this role has expanded so that now psychiatrists are being called upon to testify in every stage of a death penalty trial. From the very beginning, psychiatrists have been very uncomfortable in this role. And this has this has sparked big debates within the profession itself. On one side, there are opponents. They say this active is barbaric, and the American Psychiatric Association should call for complete abolition of the death penalty. On the other side, there are the moderates. They said, if the APA calls for a ban on capital punishment, what value will our testimony hold in court? When everybody already knows that we are biased, how will the objectivity of the profession be maintained? Instead, the APA has advocated, by way of numerous amicus briefs that have been filed in the last 25 years in cases of relevance, and the APA has also called for a moratorium to the death penalty in the United States unless it is applied reasonably and with fairness. And this moratorium was reaffirmed by the APA in 2014. Now, what remains clear is that this is a very thorny and complex issue, and these debates will stay alive till capital punishment stays in the United States. The debate will stay alive not only in psychiatry, but in society at large. Thank you.
Dr. Realmuto, did you want to open up the conversation?
That was a wonderful presentation. That was the detail, the step-by-step analysis of the thinking of the culture over time was just exquisite. My comment is, apparently we only have to be better than lightning strike to be an expert in this area.
Yes, and Dr. Grigson in Texas demonstrated that for many, many years, and nobody could stop him. And the unfortunate part about it is that Dr. Grigson was an elderly Southern gentleman who spoke with a seductive drawl, and he used to seduce his juries. He was like an old grandfather telling a tale to his grandchildren, and the juries believed him. And they said, Dr. Grigson, and there are recordings available online. You can actually go and listen to him speak. He is a prolific speaker who was nicknamed Dr. Death because he literally assisted in the death of so many individuals.
There's an associated issue, and that's the point at which minors are thought to be adults, and that's changing. And solitary confinement of juveniles and who should be prosecuted as an adult. There is a cultural phenomenon going on here.
Absolutely. There is a drastic shift in the culture within the United States, and technological advances have contributed to that. Brain sciences, where it was not 50 years ago. And so we know that juvenile brains do not attain development sometimes as late as the age of 25. And so how can they be held culpable for the same crime?
We're now seeing increase in adolescent boys particularly killing mass people in schools and elsewhere. What about them being transferred to adult court and thus subject to death penalty?
Right. So up until the 60s and 70s, the juvenile courts was run very, very differently. It was a totally different ballgame than adult courts. The juvenile court was run like a family. The parents were called. There was a troubled child. What should be the right solution for this child? There were very, very few reform institutions for juveniles. Most often they were sent back home with some, a tap on the back of the hand with some community service, and I want you to do this. And, the judge would talk to the juvenile and try to incite some sense of morality in the delinquent juvenile. In the 60s or 70s, I'm forgetting the exact date, there was a landmark Supreme Court case. It was called In Re Galt. And that, along with a couple of other decisions during that time, ensured that juvenile cases could be transferred to adult courts if it was assumed that the juvenile has attained sufficient emotional maturity to be treated as an adult. To me, that was one of the worst things that happened for juveniles in this country, because now even 15-year-old prosecution automatically will ask for a transfer to adult courts, and even 15-year-olds and even 14-year-olds in some cases are being tried as adults and given the same punishment as adults. And the sad part is they are being held culpable for their decisions at such an immature age for the same crimes.
If I could ask you if you have a comment on Dr. Philip Resnick, a psychiatrist, who was saying that the man in Colorado who killed those people in the theater should be killed. Do you have any comments on him as a psychiatrist proposing the death penalty for that young man who did have the background of potential psychiatric illness, may have been in the prodrome, was dressed up in a costume when he went there, etc.?
All right. So this is a complex issue, and everybody has a personal opinion. Every individual does, every psychiatrist does, every mental health clinician does. Everybody in this room has an opinion one way or the other. If a prominent psychiatrist, one of the most prominent psychiatrists in the country, is pro-death penalty, it does not surprise me, because the ethical conundra here are several. Let me ask you this question. If the state legitimizes death penalty for some crime, any crime, let's say heinous murder or repeated murder, are psychiatrists or physicians ethically obliged to carry out that sentence? Or is it unethical not to carry it out? Because right now, the individuals who are carrying out lethal injection are sometimes not able to find veins. They don't know how to monitor vitals. They sometimes declare death prematurely when the person has not died. Now, in that scenario, is it helping the individual or is it harming the individual? This is a complicated question. And the interesting part about the ethics of death penalty is that we are never, ever able to separate it from our own personal opinion, one way or the other. And there is a lot of literature discussing how physicians are and will never be able to, obviously we are sworn to the Hippocratic Oath, but B, also never be able to get rid of their own personal prejudice, either to or for or against the death penalty, in coming to that conclusion, whether their practice is ethical or not. What the AMA says is that whether a physician chooses to be part of this process or not is their personal preference. But once they do decide to be part of this, these are the things that are ethical, and these are the things that are not ethical.
Just one other comment. On the other side, Dr. Raquel Gore, a psychiatrist in Pennsylvania, she testified in defense of him and talked about, with the emergence of prodromal or psychotic illness, there is a difference in the brains of the people compared to a control group. Now, even though she's an amazing expert in that area, it obviously did not defend him.
Oh, yeah, there was, so I know that case, a little bit about that case. The prosecution expert examined the individual for a total of 100 hours, and he had videotaped testimony of that. And the defense experts, there were several experts, also put together evaluated the individual for 100 hours. There are many things that factor into whether an individual is declared not responsible by reason of insanity or not, especially in a capital crime. The expert testimony is definitely one piece of it. But the biggest piece, of course, is one is what is the legal standard? And the McNaughton standard, a narrow, restricted McNaughton standard, is the legal standard in Colorado, which is much more restrictive than, let's say, the standard used in New York or Connecticut, which are modified legal standards of the Model Penal Code that was given by the American Legal Institute. Thirdly, the big influence, of course, is public opinion. This is an individual who has murdered several individuals in cold blood. Many of the victims who survived, many of the relatives would have come in the sentencing phase and testified in front of the jury and given a detailed account of how much their suffering was. And so public opinion, legal standard, scientific testimony, and what the jury finally feels about the case are just a few of the factors that determine whether an individual will be sentenced to death or not. Now, in this case, even though he was not given, I should say that his plea of not responsible by reason of insanity was not accepted by the jury, his death sentence was commuted. The jury said that he should be given life in prison and not the death sentence. Gentleman to the right.
Psychiatric community and psychological community also has the problem of addressing whether or not there is actual free will. Neurophysiologically, it's not clear whether or not humans actually have free will, have the ability to make conscious choice.
And absolutely, and I totally agree with you, and that is where the gray of the psychiatry does not meet very, very well with the black and white dictates of the law. Because the law only sees presence or absence of free will. It does not contemplate on it.
We're right at noon here. Our learners and all of us are lucky to benefit from your expertise. Thank you.
Thank you.
Acknowledge the Veterans Day holiday and take a moment to
Thank you. The very next year, 1846,